Well, good afternoon, everyone. It's David Leash, your proud host of Leaders on the Frontier Live, and welcome to everybody from coast to coast to coast, as we say here on Leaders on the Frontier. We're grateful to see everybody joining us. Good afternoon, Prairie, Kenzie, Matthew. There's so many people that are regulars here on the program, and we really appreciate your comments and your questions on this day, August the 28th, 2025, the year of our Lord, as we look to the issues that our nation faces. And there is a lot going on. And today we're going to have one heck of a conversation about a decision that has frankly sent shockwaves across this country. And I don't think that's any overstatement. It's the Cowichan decision in Richmond, BC. That decision really puts into question a lot of things, including what is it called again? Oh, yes, property rights. And so we're really grateful to have today. We're going to have an incredible panel join us in a moment. Two gentlemen, lawyers no less, talk about their perspective on this decision, its significance to you as Canadians. Are we being too overly dramatic when we say it? It really puts into question, do you own your home? Imagine that. Does it put into question our property rights that we've often taken for granted in this country? So let us hold hands together and dive into this question. And as people come on to this discussion, I wanted to, of course, thank again our audience. We really do appreciate your questions and comments. We get thousands of them every month, and we do appreciate them. So I did want to highlight a couple headlines that I thought were rather interesting. And there's so many of them, but it's interesting. This week, you may have noticed that there's new data from the Department of Immigration, Refugees, and Citizenship Canada that shows that Canada is already on track to exceed its 2025 targets. This is really interesting because there's been, in the first 7 months of 2025 alone, Canada has accepted 246,000 new permanent residents, according to the data released by the department. And if this level keeps up for the rest of the year, Canada is on track to bring in approximately 422,000 new permanent residents alone. And that's just in one category. It doesn't account for refugees or temporary visa holders. And I believe, if memory serves me correctly, the numbers for temporary visa holders in Canada is well over 3 million. So I think that is a very significant issue. You may have also noticed in other news that there's a CSIS poll that was just released this week. Canada is a dangerous place, according to that poll, where nearly 6 in 10 Canadians feel their country is more dangerous than 5 years ago. Before Russia invaded Ukraine, India was linked to the murder of a Sikh Canadian, and a Canada reckoned with the accusations of foreign interference. So it's very interesting that the numbers were that high. The poll was done by CSIS as a way to understand better the mood of the population. But how is that? What do you think? Do you feel safer in this country or not? It's also very interesting that an Alberta health minister defends the $100 COVID shot fees that have been introduced. And this is during a time when in Alberta alone, some $44 million worth of COVID vaccine shots were discarded because the uptake has been relatively low. I believe the figure this past year for the federal government was $1.2 billion worth of vaccines were put aside because they were not used. Imagine that. It's interesting. There's a comment here from Akasha who says, and they sealed the foreign interference files for 99 years. Nothing to see here. Huh, that's a great question. Actually, I'm impressed by that because that's true for those of you who read the report on foreign interference. It's a very interesting report. And why isn't it that these things are not transparent? That's a key principle in good public policy is, of course, transparency. And without transparency, you can't have accountability, can you? So life goes on. In other news, we've got a very interesting story. Two First Nations have formed a joint partnership with a transport company to purchase the Port of Stewart, a bulk terminal, on a very interesting piece of geography. It's on the Portland Canal that separates British Columbia and Alaska in that corner of the country. And so it's interesting that those two First Nations are acquiring that port for economic activity. So bravo on them. It's also very interesting that we have delegations going to different countries. The Prime Minister, I believe, also had a number of ministers in tow, including the Minister of Energy, where there was meetings with Germany, the president there, to talk more about energy ties and exporting more LNG. And it was very interesting how there seems to be signals that show a different policy in terms of energy exports from this country to Europe. Imagine that. Wouldn't that be something if that's an opportunity? And meanwhile, it seems like we're still pursuing policies to get rid of the automobile. And so the leader of the opposition, Pierre Poilievre, was taking aim at that one, saying that the calling out the government to repeal that policy, and saying we need to move away from those EV mandates as the demand for electric vehicles continues to decline in this country. So that's kind of some highlights I wanted to share, including, and lastly, an interesting one about the CBC, where the CBC is choosing to fight a recommendation or an order, actually. CBC Radio is going to court to defend its refusal to disclose the subscriber numbers for its GEM streaming service. The move comes after the Information Commissioner ordered CBC to make available the number of paid subscribers to GEM. And a spokesperson said the public broadcaster believes the Information Commissioner's interpretation of the law is wrong. And it's interesting, this suit is being brought forward by a law professor at the University of Ottawa. And I believe that person is Matt Malone, an assistant professor at the University of Ottawa, who's made that Freedom of Information request. So it's a very interesting case, and that was as reported by the National Post. So this is where we're at today. Also, in terms of the House schedule, I wanted to share this calendar with you, just so you see the visuals. That is the calendar for the House of Commons sitting calendar 2025. You can see a lot of white space, but you can see coming up in September, I don't know if you can see the print, I believe the House is going to be rising on September the 15th. So stay tuned for that. So it's very interesting what's going to happen there in the House of Commons. So today, on August the 7th, we look back at that date, I think, as a historic date when a major decision was tabled by a judge. And I want to lead off with this clip.
After 500 days of litigation, the Cowichan Nation, made up of Cowichan tribes, Stamanis First Nation, Penelakut Tribe, Hallsor First Nation, and Cowichan First Nation, celebrated Friday's court decision, which determined fishing rights and title for part of the land used by their ancestors should be returned.
The courts remain an option for First Nations when we are not heard and our rights are ignored. We did not pursue this case with malice or ill will towards others.
While Cowichan Nations currently occupy central Vancouver, the land claim is for 7.5 square kilometers at the mouth of the Fraser River. The case is based on Cowichan Nation Aboriginal title to approximately 1,846 acres of traditional village and surrounding lands on the south shore of Lulu Island, now in the city of Richmond.
Someday we will. Sorry. Someday we'll be back on the river doing what our ancestors did fished, gathered, and had the opportunity to flourish in the south arm of the Fraser River. And knowing that the next generations of our communities will have the opportunity to do what our ancestors did.
Celebrations were short-lived, however, as mere hours later, BC's Attorney General announced the province will appeal the decision and ask for stay on the implementation of the court decision.
We disagree with the decision and that British Columbia will be filing an appeal and seeking a stay to pause implementation until the appeal is resolved.
The Musqueam First Nation are amongst those in opposition to the decision, saying in a statement that the court's decision ignores traditional governance practices which have guided intercommunity relationships since time immemorial. The court recognizes that the case raised complex and novel issues. The Cowichan Nation is not seeking to recover any privately held lands in the court case. For these lands, it's seeking a negotiated reconciliation with the government. Claire Palmer, CBC News, Duncan.
So there you go. There's the clip from the CBC about this decision. I believe this decision has certainly made a wave across this country as it puts into question the property rights for Canadians. And it's a complex decision. And so I went to two trusted friends of mine, lawyers, and they are two Bruces. They're two fine people. And so I want to welcome Bruce Pardy on law at Queen's University. He's also the executive director of Rights Probe and good all-around guy. And then Bruce Hallsor, who's a King's Counsel, and he's the managing partner at Western Canada's oldest law firm. And his firm is Crease Harmon. And he's practiced in all areas of law, and he's also appeared before the Supreme Court. So welcome to Bruce Pardy and Bruce Hallsor.
Thanks, David. Great to be with you.
Well, great to see you, gentlemen. I tell you, we have really got our work cut out for us here as we look to trying to parse this decision. And so I want to just start off with the basic question. What is your take on this decision? Is this a landmark decision that in your mind does put, in some measure, property rights in jeopardy in this country? Bruce Pardy, do you want to go first?
Sure. So the short answer is yes. Yes, it does put private property in question. You'll note that in the CBC report, they noted that no private property was targeted by the claim. That is, nobody's house was taken, and that's true. But that avoids the main point, which is, as the court observed, that Aboriginal title, where it is made out, is a prior and senior right to fee simple. And fee simple is what people own in their homes. So in the event that an Aboriginal claim was successfully made out over the land on which your house rests, then in principle, according to this court decision, in principle, the Aboriginal right, Aboriginal title would take precedence. Now, last fall, there was an Aboriginal claim made out in New Brunswick. And in that case, a similar kind of situation. But in that case, the judge of the New Brunswick court said that where this kind of claim is successfully made out, the government might be instructed by the court to use its powers of expropriation to take away the private land and hand it over to the Aboriginal group. So the short answer is yes. It is possible that private land that is owned by private individuals could be endangered by future Aboriginal title claims.
Wow. Bruce Hallsor, your comment?
So I guess I would say it is a landmark ruling for sure, but I don't think it's a surprising ruling given the path of jurisprudence on these issues over a 40-year period. For more than 40 years that I've been following it, First Nations groups and people who advocated for land claims always insisted that private fee simple land is off the table. That's not what they're talking about. They're talking about claims to Crown land and
yes,
publicly owned land. And that's been the mantra that's been repeated in the media from time to time. And it's always been there to try and make people feel comfortable about it. People living in cities, well, it's just talking about a bunch of mountains somewhere. We're not talking about anybody's house. And I think Bruce would probably agree that people who've been reading cases over the years have seen that that's not quite true, but it has never broken into the public as it has now. And that's why I say it's not particularly surprising. We made a decision in this country not to recognize property rights as a constitutional right in our Charter of Rights some time ago. We made a decision to recognize undefined Aboriginal rights in our Constitution. And when those rights get defined to include property, and they go up against not constitutionally recognized fee simple property rights, it's something I think a lot of us could see coming, and it means appealing this decision is important, but there's a whole level of conversation that has to happen about this, because you're absolutely right about the New Brunswick case. There was a case in Ontario a couple of years ago about a beach that was that was turned over to Aboriginal interests, and British Columbia has a little bit of a different land title system than they have in New Brunswick. We have a Torrens system, so your fee simple title is guaranteed by the province. So, if a court decided to take my house and give it to a First Nation, I would be entitled to compensation as of right, but that doesn't mean my property right is protected. And
okay, so I want to pick this up here. So this is, you've heard it here today. There's a big question mark now regarding property rights in this country. And so I want to go back to you, Bruce Hallsor, because you said something that I think a lot of Canadians would be shocked by. You weren't entirely surprised by this. I mean, we've kind of seen this train go along this path now for decades. If that's what I'm hearing, is that true? What do you mean by that, Bruce Hallsor? Why do you say that wasn't entirely a surprise?
For most of the history of British Columbia, our provincial government took the position that it had nothing. It didn't have any obligation whatsoever to First Nations. The Treaty of Union, where British Columbia entered Confederation in 1871, made it clear that in the term of the treaty, Indian and Indian lands are a responsibility of the Dominion. And so provincial governments from 1871 forward took the position that whatever claims there may be, those are claims against the federal government. Nothing to do with us, nothing to do with Crown land. If the federal government needs to compensate monetarily, that's up to them. Mm-hmm. That all changed in the 1980s, and during the time that Delgamuukw was being litigated. And Delgamuukw, and this is going back to the 1980s.
What's Delgamuukw?
Delgamuukw was a seminal decision in advancing Aboriginal title rights, and it wound up and down through the courts in British Columbia, the Supreme Court of Canada, but it essentially established that very importantly that oral history is evidence that a court can accept. You don't need documents. You can simply provide oral history, and that if it's unrefuted by archaeological evidence or documents, that'll be accepted as truth. That was a big evidentiary step for proving historic uses, but it essentially established that any First Nation that could show that it had exclusive occupation of an area and control of an area before the Crown asserted sovereignty over British Columbia and by extension other places in Canada, if they could establish on the facts that they had exclusive occupation over an area, they would have a valid title claim. And then Delgamuukw that's what the Supreme Court of Canada said in Delgamuukw, remitted it back to a trial court, which had originally dismissed the claim, and then the matter was settled. But marching forward 25 years, in the Chilcotin decision, there was a large tract of land in the interior of British Columbia where the courts found, as a matter of fact, in trial, that there was exclusive occupation. A lot of people read Delgamuukw as thinking, well, exclusive occupation means your village and areas where you could have kept out intruders, but it wouldn't mean huge tracts of mountains where you may have passed by from time to time hunting or gathering. But that all changed with the Chilcotin decision, and that's 10 years ago. So
Wow.
it's that trend.
So this is, I want to turn to you, Bruce Pardy. Was it a surprise to you that the framework of this decision was handed down on August the 7th?
No, Bruce is entirely correct. This is the logical extension of the way that the Supreme Court of Canada has expanded the meaning of Section 35 and the nature of Aboriginal title over time. So let's just go back to the Constitution just for a minute, because the point that Bruce is making is very important. Property rights are not protected in our Charter of Rights. Property rights appeared in early drafts, but there were objections and they were taken out.
Yes.
On the other hand, Aboriginal rights did not appear in early drafts, but did appear in time to be included in the final version. So what we have is no constitutional protection for property rights except for Aboriginal rights. Now, those Aboriginal rights are recognized in Section 35. The significance of Section 35 is that Section 35 is not part of the Charter. That is, Section 35 is not subject to the notwithstanding clause in the Charter. In other words, there is nothing that a legislature can do to get around the Supreme Court's interpretation of what Section 35 means. Now, Section 35 on its face says that Aboriginal rights as they existed as of 1982 are recognized and affirmed. But since the Supreme Court now basically has carte blanche to decide what the nature of Aboriginal rights is in this country, they have taken over time an expansive view and discovered things that were never there, at least to the knowledge of the rest of us, before 1982. And that's part of the story that Bruce is telling with these various cases. And as over time, the nature and the boundaries of those rights have expanded, and this decision is just one more step along the path. And nobody should be surprised at what this court has said. It's not inconsistent with the trajectory that the Supreme Court has placed along this path. One of the disappointments is that everybody now is saying, what is going on? Well, this has been going on for a long time.
Wow.
And
sounds like we've been asleep for a few decades here. Bruce.
Yes. Now, this is just a trial decision, so it's going to be appealed, and we'll see what happens in the end. But I wouldn't be surprised if the appeal courts said, yeah, makes sense. If you're going to apply Supreme Court jurisprudence to this question, then this is the proper result.
So how long is it going to take for this thing to be appealed? That could be years, couldn't it, Bruce? Pardy?
Sure, it could be years. And well, the good thing actually so far is that the BC government of all governments has announced that it's going to appeal it. I mean, I wasn't sure that they would, because elsewhere they've been handing out Aboriginal title to various territories by agreement.
Right.
And so I had half a mind that they would just say, that's, fine with us. Let's just carry on. But it sounds like they will. Yeah, Bruce, a good point there. This judgment is not a lot inconsistent with the agreement that this provincial government signed and the federal government with the Haida Nation just last year, where the Haida Nation was given not title, but certainly decision-making authority over private land on the on Haida Gwaii or Queen Charlotte Islands, part of the province, a large territory. And as the judge noted in this decision, both the federal and provincial lawyers were restricted on what they could argue. They've adopted DRIPA, UNRIP, these principles that governs their ability to argue certain points. So I'm not sure on appeal that's any different, because you've got a provincial government that is arguing the case, but not arguing every point it could make because of some policy decisions that it has made.
Interesting.
And some of these points were made by Richmond, the municipal government that was part of the case. They weren't subject to DRIPA. But interestingly, of course, and private landowners who weren't named as parties, but are definitely affected now by the words of this decision, may have other arguments to make. And to me, it's an open question as to whether there might be groups that will intervene on an appeal to make arguments that the governments, for policy reasons, can't make.
Okay, so we are talking with Professor Bruce Pardy in law and also lawyer Bruce Hallsor about the landmark decision, the Cowichan decision. Are your property rights in jeopardy now in this country as a result of this decision? So pay attention. I am having this conversation. It's a historic decision. It's interesting. Our comments from our audience. Sheridan Forbes says private property rights are trumped by property rights of a community. According to that judge, your property rights basically are null and void. You can't invest where you have no property rights. What do you say to that, Bruce Pardy? Is Sheridan onto something here?
Yes, well, that is the constitutional situation. The group rights recognized in Section 35, the Aboriginal group rights, are constitutionally protected. Your private property rights are not. So even putting aside the Aboriginal title question, everybody ought to know that your private property rights are not guaranteed. There is no constitutional impediment to the government deciding one day that it's going to pass a statute and take your house away. We have those statutes, expropriation statutes, in all the jurisdictions across Canada. Now, those statutes do say that, when you're going to take somebody's house for a highway, then you have to pay them compensation. But that's because they've chosen to put that in the statute. Constitutionally, they don't have to do that. They can do whatever they want with respect to your property because we made a decision around 1982 not to include property rights in the Charter of Rights. So the decisions that we made all have consequences, and those consequences are now coming home to roost. Those two decisions that we made that at the time may not have seemed connected now seem very much connected. Number one, the decision to not include property rights in the Charter, and number two, to include Section 35, the Aboriginal rights, in the Constitution. One of them is protected, the other one is not.
Wow, this is quite a revelation. It's interesting. On August the 9th, Premier David Eby, the Premier of British Columbia, said, quote, "Let me be clear, owning private property with clear title is key to borrowing for a mortgage, economic certainty, and the real estate market. We remain committed to protecting and upholding this foundation of business and personal predictability and our provincial economy for Indigenous and non-Indigenous people alike."
Yes,
so
which
Bruce
is
Hallsor,
nonsense.
what do you...
Sorry, go ahead.
Yeah.
Can I just say that is nonsense because his government has been making agreements giving management and control, and in some cases title, to Aboriginal groups in a way that threatens the private property rights of those people who live in those territories. So what David Eby just said, the quote you just read out, is utter nonsense.
Would you agree, Bruce Hallsor? Nonsense?
The only way you could square that statement with any kind of reality is essentially what he's saying is the government will underwrite these land claims. So if there's a piece of if there's a piece of private property that a court or a treaty decides is Aboriginal property, then either you're going to protect that private property as a matter of policy, not a constitutional right, but as a matter of policy, which means everybody, all of us, are going to pay a whole bunch of money for that property to the band as compensation for a taking, or we're going to dispossess the fee simple owner of that property and compensate that person. But, the only way to square that is to say we're going to spend trillions of dollars potentially either compensating fee simple owners or compensating First Nations for fee simple land. Money we don't have. Money that there's no way that any government in Canada can afford the kind of dollars that it would require to essentially buy all of the real estate in the province or all of the valuable real estate, because that's what we're fighting.
Right. Right.
Okay,
Right.
so this
right.
is truly mind-boggling, because I look at this and I think we can't be sane and rational policymakers in this country if we think we're going to go down a path and say the government, and you hit the nail on the head, Bruce Hallsor, who's the government? We're all on the hook now for compensation backwards and forwards everywhere you look on this issue then, right? Somebody's got to pay. Like, there's no free rides in this. Like Bruce Pardy, I don't understand
You can't
how
say that. You can't say that
forward.
I own my house and so does the First Nations near me.
Right. Right.
Somebody's going to be there, and somebody's going to get a bunch of money.
Exactly. Yes.
Wow.
And let's go back to the point of the case. The point of the main, for me, the most important statement in the case is Aboriginal title is a prior and senior right to fee simple.
Exactly.
So in that context that Bruce just described, Aboriginal title takes precedence. That's the simple message.
I have a confession. I've not read the an 800-page decision yet. I've read the summaries, but that is the punchline: is Aboriginal title is a senior interest to fee simple title interests.
Right.
They come first in the line. Period.
Correct.
Is that what you're saying?
Yes, that's what I'm saying. And the situation is as Bruce describes it, but I might even say that in some cases it's worse, because Bruce alluded to the Haida Agreement. Now, the Haida Agreement claims to do a lot of different things that conflict. Haida, the government of British Columbia has claimed to recognize Aboriginal title over Haida and given the Haida Council management powers over what happens on that territory. At the same time, the agreement says that fee simple title held by individuals will be honored. Right? Those two things cannot coexist. The Supreme Court of Canada has said quite clearly a number of times that the nature of Aboriginal title is communal, and it can be used in all kinds of different ways, but there are some restrictions on its use. And the one thing that the Aboriginal title cannot be used for is to be parceled out to be granted in fee simple. You can't have fee simple title in a territory also governed by Aboriginal title. That is one of the things that the agreement for Haida claims to do. So if you own private property on Haida and you read this agreement and the agreement says, "Oh, don't worry about it. The fee simple private title will be honored." That doesn't make sense. It doesn't make sense according to the agreement's own terms. And so there's a lot of pretending going on. There's a lot of pretending on the part of the BC government, basically saying, don't worry about this, folks. Your house is safe. We're honoring your title. Well, no, they're not.
Okay, so this is very concerning, and I get it. There's different perspectives and analyses, and bring them on. I know that I've seen some commentaries, say, well, look, people, like, take a Valium. This is not a problem. We need to accommodate these issues and negotiate them out and, let cooler heads prevail. Well said. But what you're saying is kind of inescapable logic. It's either one or the other. You can't blow and suck at the same time if Aboriginal title supersedes everybody else. I don't understand then how this isn't an issue. So in this context, this appeal that's being done by the BC government then, is it fair to say that's more of a, like, why are they appealing then? I mean, they've all been in on it. They've kind of moved us further down this road where we are. Is it just a head fake? Is it just theater then? Bruce Hallsor, do you want to, what's your comment on that?
The government's position was that this is different than the Chilcotin case, which was mostly over crown land, unoccupied land by anybody. There were some rancher licenses, forest licenses. The government's position has always been that land that was reduced to fee simple titles and entered into the land title registry in British Columbia was alienated from First Nations claims. There are a number of common law principles that protect private property that weren't really argued strongly and maybe would be on an appeal. I mean, there's a common law principle of if I've held title for value and I paid for it, that is an indication that I should have that title, and that would supersede other claims. There's a common law principle that if you use a property for years and years and years and nobody complains about it, everybody recognizes your title, that through common law principles you acquire certain rights to that title. There's a number of principles that are to be explored. The problem, of course, is none of those are constitutional. None of those are enshrined in the Charter of Rights. But there is a case, and even the judge in this case recognized that when the Crown did a taking or made a grant, that those may be respected. One of the distinctions in this case was, did it happen before British Columbia entered Confederation or after? These particular properties were not reduced to title until after 1871. And the judge said, well, after 1871, the province had no jurisdiction over Indians and Indian lands. So how could it have extinguished title by the Use of the Land Title Act? Whereas for older parts of British Columbia where land was created before 1871, perhaps if you look at this judgment, you would say, well, those were extinguishments of Aboriginal title because they came directly from the Crown that was sovereign there, and there was no constitutional impediment. I don't know. There's arguments around the edges that I can see just reading this, and I could see that interveners or perhaps even these governments might sharpen those arguments on appeal. But fundamentally, we come back to the problem that Bruce Pardy articulated at the beginning. You have a constitutional right versus a non-constitutional right, and it's difficult. We have a systemic issue here. This isn't a rogue judge.
Right.
This is a systemic issue we're going to have to deal with.
Okay.
Could an appeal be successful and modify it? I think so, but it's not.
But Bruce, in that context, though, to be fair to the judge was doing their job.
Yes.
Right.
Yes. Yes. Now, if you're a judge, you have a certain amount of room and discretion and ability to craft your decisions the way you think you want to. But this is not as Bruce just said, this is not some rogue judge deciding on a completely different path than the one that the Supreme Court of Canada has laid down. Not at all.
Wow.
But one thing we maybe should just fill in here. Bruce earlier alluded to UNRIP and DRIPA. We just clarify what those things are.
Yeah. What is that?
Right. So UNDRIP is the UN Declaration on the Rights of Indigenous People. It's a UN General Assembly resolution. And at the time it was passed, Canada voted no, along with the US and Australia and New Zealand. And then they reversed that decision when the Trudeau government came into power. They reversed their objection to the resolution. But now it's just a General Assembly resolution, and as such, it's not binding international law. You can't take it and enforce it in a Canadian court. You can't take the resolution and go to a court and say, this resolution says this. You give me these results. The court will say, no, it doesn't have that status. So it was an aspirational document, an outrageous one, but aspirational. It basically said that Aboriginal peoples are entitled to all the lands that they traditionally owned, occupied, or otherwise used or acquired, and they're entitled to have it and develop it and to control it and to own it. So that's the kind of aspiration we're talking about. So everybody said, look, don't worry, it's aspirational, it's just symbolic, just leave it alone. Okay. The BC government and later the federal government passed legislation incorporating UNDRIP into provincial law. They passed a statute that said it is the responsibility of the BC government to make sure that the laws of British Columbia are consistent with the General Assembly resolution. In other words, they've given themselves an obligation to do what UNDRIP says to do. And under that mandate, they are making all these agreements, giving Aboriginal title and control and management over all kinds of places in British Columbia.
Unbelievable.
And so this is not constitutionalized. This is more extreme than even the Supreme Court's interpretation of Section 35.
Right.
right?
Wow.
And so, you're now into really extreme territory. You have a provincial government that has taken it upon itself to obligate itself to basically give away land of its own province.
This is really quite sad for this country, because if we link up the dots, how do we move forward as a country? Because this has massive implications, and I'm going to try to connect some dots here. So please bear with me. We've got what are called Aboriginal land acknowledgements. We see them right across the country. They come in different forms. We've got all kinds of ongoing land claims and settlements that the federal government and different provinces, it varies, are handing out, BC being at the forefront of this. You've got this decision. You have all kinds of other related decisions where the narrative is the same, is that we're all white settlers. We're all visitors to this land. And now it's unfolding. And there's even parties and universities that emphasize the land needs to go back. So this is all consistent, isn't it? That we are truly now visitors in this land. And how would anyone rationally invest in a country where you can't even have property title? Am I being too histrionic and dramatic here?
Well,
Where's the future of this nation here?
I think we've seen the future already in resource development in this country.
Yes.
If you want to do any resource development in this country, you'd better have a First Nations equity stake, or you're not going to get approval. That's the reality of business in Canada in a lot of it, and that's going to come to urban areas with other kinds of business development. I think that's the path we're on.
Bruce Pardy?
Well, I think this is the unsurprising place to land when your country is built on the idea that different kinds of peoples can have different rights. We are living in a country where your rights depend upon lineage. And that is a terrible idea. I mean, I put it this way. In an actually free country, Aboriginal rights should not exist, because what they mean is that the law is distinguishing between people based upon lineage. If you look back in history, invasion and migration and mixing is the history of humanity. It has happened everywhere.
Universal. I like to use the example of Britain. Now, the Romans invaded, and then the Saxons took it over, and then the Normans came and conquered it, and those populations mixed. And today in Britain, just imagine the situation if today in Britain the law tried to distinguish between people who had Roman heritage and Saxon heritage and Norman heritage, and gave them a different set of rights depending upon who your parents and great parents and great grandparents are. It would be ridiculous, because it's the 21st century and everybody has mixed. The culture that exists is a different culture than existed at any of the times of those developments. Okay, and so today the people are British. Doesn't matter if you're Saxon or Norman or whatever. Okay. Yeah.
That is not the case in Canada. In Canada today, it still matters who your parents are.
Bizarre.
And that is an intolerable situation. And in order to be able to fix this, I think we have to reject wholeheartedly the idea that your rights depend upon your lineage. That cannot stand. Now, we have a practical constitutional problem, because Section 35 is there. How do you get rid of it? But the first stage in that is for Canadians, or a critical mass of them, to say Section 35 was a mistake. And we don't believe anymore in the idea that there are different peoples in Canada. There's just people.
Wow. So most Canadians would believe that everyone in this country are equal. But you've just outlined, Bruce, how both of you have outlined how this has become a train wreck, where inevitably we're coming along this path where we've got decisions like this that clearly in the light of day show that Canadians are not equal now.
Well,
We've got two different types of citizens. Is that, am I hearing it correctly
this
here,
is,
Bruce Hall?
again, this is not new.
No.
Canada was from the founding of Canada. This has been the case. Section 35 is new, and the property rights are new. But the Indian Act and settlement with First Nations was part of the pre-Confederation arrangement of this country, and there for the entire history of our country, Aboriginal people have had different rights than other Canadians and different obligations. There's some taxes they don't pay that we pay as non-Aboriginals. Their voting rights have been different at different times. This is a complicated thing to undo. If you want to go to a country where, the apartheid system in South Africa, when they set it up, they came to Canada and they looked at our legislation for how to figure out to differentiate and how to define people based on race. So this is a part of our history that's woven into all of our legislation. It's not an easy thing to undo. I think almost everybody would agree. We have discovered in this century, in the last century, that racism is a bad thing and classifying people by race is bad. But we have this exception that has long historical precedent here, and the group that maybe at one time was hurt by it but is now benefiting from it isn't going to easily want to give that up, and it's constitutionally enshrined. So I don't know how,
this is very disturbing. So in this context, we've had a far-reaching conversation here. The implications here, you can see why this is an earthquake of a decision in terms of its impacts across the country. It's hard to fully digest, and it's going to take time. So there's this appeal that's happening, and both of you have given nuance and analysis about the limits of that appeal and the ironies to it as well, given the BC government, as an example, has been so instrumental in this policy direction. So my question is this: if that's going to take years to resolve, don't we need, as a country, an intervention? Don't we need real political leadership that's going to come to bear here in terms of policy action? You've alluded to it, like Section 35 is a big problem in our Constitution. Because otherwise, why would any rational actor, and I'm speaking this sincerely, how do you invest in this country if your property rights are in doubt? Like Bruce Pardy, look at this situation and say, if you were a advisor to the Prime Minister or every premier, what would our advice be? Because this uncertainty is deadly to any type of business, private investment. And that's where we're headed. We're already on a decline in this country.
No doubt. All that is true. But we are taking a lot of things for granted, like our political leaders are acting in the best interest of the country, or that they are acting in good faith, or that they are acting on evidence and rational thinking. Those things are very much in doubt. And if you like, we have a political class that is almost self-immolating. You can't explain the BC actions in any other way but to say that it's kind of suicidal in the kind of ways that you're talking about. It makes no sense. It's an untenable set of developments. If I was a new government, a new premier of British Columbia with a different plan, a different agenda to try and fix all of this, there are a couple of things that can be done, but there's a lot of things that constitutionally are not possible. So you can repeal DRIPA. DRIPA is the statute that incorporates UNRIP into BC law. That would be the first thing. And by the way, that statute, when it was passed in 2019, was passed unanimously by the BC legislature. Unanimously. Every single member of the provincial legislature voted in favor of that statute. Every single one of them. Every party. But I would repeal DRIPA and get rid of that agenda. Now, you can't do anything about the Section 35 because it's in the Constitution. The courts control the content of that. But you could at least you could at least address the kinds of problems that you're talking about and give as much stability and security and guarantee of compensation than you can to this uncertain property situation. But right now, our political leaders, frankly, of all political stripes, have been adding to this problem rather than fixing it.
Okay, well, it's quite an insight that the entire political class in many ways has kind of been betraying its own citizens, Bruce. And I think it's a very powerful summation. And I look at this, I mean, I think most Canadians would say, look, we're all Canadians. We need to all work together in peace and hard work, and we need to have a stable environment where we can build this incredible country together. But this is yet again another major challenge. So, Bruce Hallsor, what would be your plan of action? What would you recommend we do, given this train wreck of a situation?
We're getting out of the realm of legal analysis and into public policy now.
Indeed.
But I'll venture in a little bit. Look, I don't, we hear a lot about reconciliation. And I think Canadians broadly feel that we need to reconcile the relationship between the majority of Canadians and First Nations. But I'm not sure that politicians understand what that means. Reconciliation is when two sides come together and they exchange grievances and they settle their grievances, and they, in a spirit of cooperation. What we've seen since reconciliation has been announced is essentially a very one-sided process, where one side lists demands and the other side apologizes for not having met them quickly enough and meets them, and then and that doesn't end the demands. That simply leads to more and more. Like, there needs to be some finality and some kind of arrangement. As you mentioned, investors, people need certainty. It may not be the certain arrangement, might not be your ideal arrangement, but certainty only comes when there's finality. So, when we settle land claims, like the Haida one, it's not actually a final settlement. It's always an interim settlement, and it opens up the door for more to come down the road.
Wait a sec. You mean a land claim settlement is not a settlement? It's always an interim agreement? There
are always interim agreements, and the First Nations don't give up the right to amend or ask for more or ask for it to be refined.
It's a big black hole.
So this is
the Nisga'a may be the one exception to that. When I think about it, but I'm not even sure about that. And certainly in terms of the broad reconciliation agenda, it's always governments agreeing piece by piece to things without any finality.
And there's no plan. Exactly. Yes, there's no plan. There's no overall strategy. It's just it's a feeding and a continuation of an endless stream of government largesse.
So what there needs to be is perhaps the majority will concede certain things, but hold back the enacting of those until we know that we've dealt with everything, because that's what true reconciliation is.
Right.
And we also, as the majority, might want to say, how do we view this, and what are things we would like? And in negotiations, which, as a lawyer I'm involved with all the time, you look at interests of both sides. You don't look at positions, and you try and find a way that people can work it out and work together in the future. As Justice Laforet said in Delgamuukw, we're all going to be here for the future. We need to find a way to work together. And I'm afraid the current agenda does not get us there.
But the irony is that this is being called truth and reconciliation, and it's neither. I mean, I prefer to think of it as fiction and capitulation. The whole thing's made up.
Wow. This is an astounding conversation. I think this has been I believe it's a revelation for a lot of our audience, if not most Canadians. So I'm having this conversation with two very gifted lawyers, gentlemen, Bruce Pardy and Bruce Hallsor. So I I mean, the comments are coming in here fast and furious. And I guess one of my questions would be, what do we do as citizens in this situation? Like, how do we find voice to say this country is frankly not workable on this pathway, where it's never ending, never ending process of, quote, reconciliation. It's one way. This is a situation that almost denies the reality that, well, Canada was conquered as a land. And I mean, that's the eternal story of humankind throughout human history in all cultures, including Aboriginal. So this is nothing new, but the reality is it's 2025. How do we live together in a way that respects those rights of citizenship, so we don't have two tiers of citizens? I just think this is a dead end. So any advice to citizens, Bruce Pardy, in terms of what we can do to move this ball forward? Because otherwise, I don't know why anyone would stay in this country. And it's horrible to say that.
So if you'll forgive me, and I do not mean this facetiously. I mean, one of the only ways through this, frankly, if people are really interested in finding a way through, to move to Alberta and help them leave the country and establish a new country that does not have two-tiered rights.
Wow.
Because otherwise, the only choice is to try to amend the Constitution, and that has been designed to be very, very difficult, almost impossible, especially on an issue like this. So our political elites have maneuvered things, and maybe inadvertently, I don't know, but have maneuvered things so that it's basically impossible to fix the problem. So the only solution left is to leave the country and start again.
Wow. What do you think about that, Bruce Hallsor? What are your thoughts?
I'm not quite ready to sign on to that yet, but I hear where Bruce is coming from. I hope that decisions like this make people wake up to see what's happening, and that there will be political change. And I hope we can find a way to accommodate ourselves and live together on a different path. But I didn't come here to debate Alberta independence. Of course, Bruce lives in Ontario and I live in British Columbia, so
Wow.
what we have to say about that. But
Well,
Another time.
I will tell you, I think that one of the hopes I have is in this audience and my conversations with so many Canadians. We get thousands of letters, and it's amazing how many people are just simply not aware of these issues. And I think we know that in Canada, we have a legacy media that doesn't really talk about these issues. Obviously, so many of them are funded by the government. But I think that this is a kind of a seminal moment in legal history in this country, again, where if your property rights are on the block, so to speak, if they are on, well, for example, in doubt, if they are uncertain, surely that will be a wake-up call to every Canadian to say this is not right, and that they have a responsibility then and an obligation to speak up and say, who's going to have a future in this country? So perhaps that's where we can find hope for this nation. I mean, I think that's a classic case in public policy where if you have enough pain, quite frankly, where people get that feedback loop from bad public policy decisions, then therein lies the genesis for people to wake up as a citizenry and say, this is unacceptable. I know that's not the best answer today here on August the 28th, but your discussion today certainly sheds a light on the significance of this issue. And I think a lot of people would be shocked by it. Do you see any hope in that, Bruce? I mean, you talk with a lot of people, but it's very common for Canadians to be totally unaware and frankly naive of this issue, I think.
And a lot more would be if not for your work, David. So thank you for doing what you do. One of the problems is that we've had a lot of wake-up calls in this country. A lot of them. This is one of them, a big one. But we've had a lot of wake-up calls, and nothing ever happens. Nothing substantial, nothing fundamental ever
Mhm.
happens about the way the country is governed, the way the Constitution is built, the way the national character is oriented. Nothing really happens. And so at a certain point, you have to figure that wake-up calls are not enough, and that something else more substantial, more disruptive of the political environment has to happen. And that's why at the moment I'm inclined to think that Alberta independence is one of the possibilities.
Okay, very interesting. I want to show you, just before we end here, a slide, and it shows money leaving this country. And I think this is part of the brass tacks argument I would make in terms of this discussion. And I want to bring that up, Madam Producer, where it shows this color, call it salmon, whatever you want to refer to it, over a long period of time. But that's a lot of money. That's some 800 and what is it? $811 billion that have left this country. And as you can see, it's speeding up. And this is not a totally up-to-date graph. I'm trying to find that more recent data. But surely this is a wake-up call. If you don't have private sector investment in this country, let alone a trust and confidence in the law that you will be treated equally, I don't know how you are a viable nation. So Bruce Hallsor, as you look at that graph, what are your thoughts about how we move forward out of this mess?
Well, look, if you're going to lend somebody money to do a big real estate project in Canada, and you look at this decision, it's going to give you pause, and you can move your money somewhere else and invest in some other country. That's why now, if you're Petronas or BP and you want to invest in an energy project in this country, you're not going to do that without a First Nations partner. That First Nations partner is not bringing any equity to the table, but they're getting equity in return for the fact that they're going to make it easier for you to do business. That is, that's not a sustainable model in the long run. It's certainly beneficial to a minority of people who are part of the lucky 3% of the gene pool that may benefit from that. Certainly, there have been historic injustices to that portion of our population, but I don't think a perpetual advantage like that is the solution either. I don't think the 97% will see that as just over time.
Well, this has certainly been a sobering conversation, Bruce Pardy and Bruce Hallsor, and I want to thank you so much for joining me today to talk frankly about a very difficult legal decision that has ramifications across this country and that we're still trying to understand and figure out. But I just encourage our audience not to give up hope, to be determined to continue to build this country. And I would urge you to share this program with your family and friends. Ask them, what do you think? Are you aware of this decision? I encourage you to share this information so that we can come together as citizens to be able to say to our elected officials, we need you to work with us to help lead and build this country and not, frankly, disable it. And I think that this decision, among many others, is on the wrong path from my respectful opinion as as someone who cares deeply not only about public policy and the law, but also the future of our country. So thank you very much, Bruce Pardy, and thank you, Bruce Hallsor, for joining us today.
Thanks, David.
All right.
Thanks, Bruce.
Thank you.
So that brings to an end our program today. It's been quite a discussion. I want to thank our audience for all your comments, and please share. We very much appreciate your feedback as usual. And let us know what you think. And in the meantime, I hope you have a great Labor Day weekend. And believe it or not, next September the 4th, the same time, same place, we'll be reconvening live. We'll be meeting with another extraordinary panel to talk about a vision beyond the Indian Act. Imagine that. How can we empower every Canadian, including our brothers and sisters who are Aboriginal to be able to say, how do we move this country forward? So make sure you join us for that one. In the meantime, thank you so much and have a great day.
Thank you for watching Leaders on the Frontier. We're a nonpartisan think tank. We explore ideas, policy, and practical solutions that can make a difference in the lives of Canadians. We do not accept any government funding. We work for you. Thank you for supporting Frontier. Visit fcpp.org to give. While you're there, be sure to check out our latest articles and research. Without open discussion and debate, you're not thinking, nor are you free. Comment below. We'd love for you to join the conversation.